Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers civil trespassing, citizens' arrests, and impersonating police officers, and is brought to us by One Stop 14th Amendment Audit Shop's channel. Be sure to check out the description below and give them the credit that they deserve. In a video posted on August 5th, 2020, Deputies Weddle and Moore of the Halifax County Sheriff's Office approached Auditor Michael Raposo in the parking lot of Franklin's Garage in South Boston, Virginia, along with several other unidentified officers. According to another video on Mr. Raposo's YouTube channel, the officers were responding to a call from the owner of the garage, Donnie Ellington, who alleged that Mr. Raposo was assuming the duties of law enforcement, as well as a call made by Mr. Raposo to report an alleged crime committed by Mr. Ellington.
Keep calling dispatch for help.
Okay, what you need help with?
Well, days ago, my RV was stolen from a lot off of Vaughn Street, across from Carter Field next to the White Pump House.
Okay.
Is there a superior here, actually?
Well, we're all on level playing field, so which...
I'd like to speak with the superior directly.
Okay. All right, well, you're speaking to me right now, so what do you need help with?
I would like to speak with the superior directly, sir. I want to make sure my constitutional rights are respected through this whole process and ordeal.
Okay, well, I'm here to protect your constitutional rights. That's what we're here for.
Okay.
Absolutely.
So who is the supervisor, though, just so I can direct my attention to the proper channel of authority for myself?
No supervisor here.
No supervisor. Okay. So, my RV was primary residence and my primary dwelling, my sole domicile. It was taken from me days ago. I immediately picked up the phone and called and filed a report for grand theft with South Boston Police Department, which Officer Perkins responded. He refused to provide any incident report or any investigation, any information regarding my RV and a call to be removed.
No crime has been committed.
Yes, sir, it has. And
look, if you can let me finish talking first, and then you can talk, all right?
Yes,
that's
sir.
how this is going to work.
Prison of a felony.
Okay, look,
now.
you're going to stop talking and listen to me, okay? No crime has been taken. You parked your vehicle on a lot owned by somebody else. You can't park it there. That means he has a legal... Code of Virginia says you cannot leave any property that belongs to you on somebody else's
thing. Can you furnish me that code?
I don't have to. I'm telling you.
Listen here, sir. With all due respect, this is why I requested a supervisor.
Deputy Moore informs Mr. Raposo that Virginia law prohibits an individual from parking on someone else's property. Section 46.2-1215 of the Virginia Code states that, quote, no person shall leave any motor vehicle, trailer, semi-trailer, or part of a motor vehicle, trailer, or semi-trailer on the private property of any other person without his consent. Additionally, Section 46.2-1200 includes in the definition of an abandoned motor vehicle, quote, a motor vehicle, trailer, or semi-trailer that weighs at least 75 pounds and has remained for more than 48 hours on private property without the consent of the property's owner. And Section 46.2-1201 states that, quote, any county, city, or town may take any abandoned motor vehicle into custody. The locality may employ its own personnel, equipment, and facilities, or hire persons, equipment, and facilities, or firms or corporations that may be independent contractors for removing, preserving, storing, and selling at public auction abandoned motor vehicles. Given the available information, it seems likely that Mr. Raposo's RV was removed from the property under the authority granted by these statutes. However, Section 46.2-1215 goes on to state that any vehicle towed by law enforcement must have been left for more than 72 hours, and Mr. Raposo claims in many of his other videos that his RV was parked on the property for less than 24 hours. Nonetheless, the circumstances surrounding the actual towing would have to be debated within a courtroom, and it's very likely that a court would find that the officers were acting in good faith when the RV was towed.
This is misprison of a felony, refusing to take a report in regards to the felony, and you're acting as an attorney practicing law unlicensed right now, which is also a crime, and you are here to solely take a criminal report. In regards to that...
No criminal report, nothing criminal has taken place.
Hold on 1 second, sir. I'm not trying to argue with you. I'm trying to educate you. Now, the Supreme Court had ruled that it is your sole duty to take a criminal report in regards, and if I am falsifying any information in regards to this report, you will be liable to arrest me. Now, with the state law and federal law considering, I'm going to educate you. Not at one point, at any point in time, was I made aware that I was trespassing. Therefore, it is a crime in regards to the removal of that vehicle from that property because nobody had made anybody aware that a crime's been committed. I'm going to elaborate for you in a clear instance. 1 second, sir.
No, he's talking, you stop talking, okay? That's how that works.
I really wanted to speak with the supervisor so I didn't get gangbanged by a bunch of people who didn't study law.
Right. Do you know the person that owned the property you're parked on?
It's not owned by a private individual. It's owned by a private corporation.
Did that corporation give you permission to park there?
This property has been generally open and accessible to the public in the neighborhood for generations, as I can testify myself to that.
Was it closed when you parked
there? There are no posting signs whatsoever that would deem any portion of that property not open and accessible to the general public.
Mr. Raposo argues that he was not trespassing on private property because there were no signs posted and no one notified him that he could not park there. Section 18.2-119 of the Virginia Code defines the offense of criminal trespass as going upon the lands of another, quote, after having been forbidden to do so, either orally or in writing, or after having been forbidden to do so by a sign or signs posted on such lands at a place or places where it or they may be reasonably seen. However, while Mr. Raposo could not be prosecuted for criminal trespass because he had not been forbidden to enter the land and there were no signs posted, he could possibly be held liable in a civil lawsuit for trespass to land. The civil cause of action for trespass to land is recognized in Virginia under the common law, which is part of a state's body of laws that comes from customs and court decisions instead of statutes. In the 1994 case of Cooper versus Horn, the Supreme Court of Virginia outlined the requirements for a cause of action for common law trespass to land, stating that, quote, a trespass is an unauthorized entry onto property which results in interference with the property owner's possessory interest therein. To recover for trespass to land, a plaintiff must prove an invasion that interfered with the right of exclusive possession of the land, and that was a direct result of some act committed by the defendant. Any physical entry upon the surface of the land constitutes such an invasion, whether the entry is a walking upon it, flooding it with water, casting objects upon it, or otherwise. Mr. Raposo could potentially be found liable under the civil standards for trespass, since there is no element of being forbidden required. But he also could argue that he was parked on the property with the consent of the property owner, which is a common defense in civil trespass cases. Even though Mr. Raposo clearly did not have actual consent from the landowner to park there, consent can also be implied from custom usage or conduct, which means that Mr. Raposo could argue that because the land had historically been held open to the public, he had the landowner's implied consent to park there. Despite the fact that the criminal statute requires that an individual be given notice that entry to the land is forbidden before the individual can be arrested for trespass, Section 46.2-1201 of the Virginia Code does not require that any notice be given before an abandoned vehicle is taken into custody. However, before an abandoned, manufactured, or mobile home that has been taken into custody can be sold or otherwise disposed of, Section 46.2-1202 requires that the person in possession of the vehicle provide the owner 120 days' notice to reclaim it.
Sir, this is misprision of a felony if you're refusing to take a report. This is why I seriously wanted a supervisor to come down here and respect my constitutional rights. What is your name, sir?
Deputy Weddle.
Deputy
Weddle.
Weddle. Violations of U.S. Code and of the Constitution are as follows. Violation of the KKK Act, which is the 3/4 Act, the RICO Act.
We need to call the FBI when enforce federal goods.
I did.
Okay.
And they refused, claiming it was civil. However, that is another instance where they are misprision of a felony and practicing law without a license. They cannot tell me it's civil when I'm filing a criminal report with all the information in regards to such.
While Mr. Raposo attempts to report violations of criminal law, the officers insist that, based on the facts of the situation, it is a civil matter. A criminal case is filed by the government against an individual for a violation of a criminal statute, whereas a civil case is filed by an individual or corporation against another individual or corporation for violations of non-criminal law. Examples of civil matters include debt collections, property and contract disputes, probate and estate cases, and, as discussed earlier in this episode, tort law claims such as common law trespass to land. Section 15.2-1704 of the Virginia Code states that, quote, a police officer has no authority in civil matters. Generally, police officers are under no obligation to take complaints from a citizen, and if they determine something to be a civil matter, they can refuse to file a report. However, states and localities can enact laws that require officers to accept certain types of complaints. But Virginia has passed no such laws that would require the officers to accept a complaint from Mr. Mr. Raposo, or limit their discretion to determine that the situation was a civil matter. Mr. Raposo also claims that the officers are, quote, in violation of Virginia Statutory Authority 46.2-1231, 18.2-102, and Virginia Section Code 18.2-119. As we discussed earlier, Section 18.2-119 of the Virginia Code is the criminal trespassing statute, and it is unclear how Mr. Raposo believes the officers are violating this statute. Section 18.2-102 defines the criminal offense of unauthorized use of a vehicle, stating that, quote, any person who shall take, drive, or use any vehicle not his own, without the consent of the owner thereof, and in the absence of the owner, and with intent temporarily to deprive the owner thereof of his possession thereof, without intent to steal the same, shall be guilty of a Class 6 felony. While there does not appear to be any case law discussing this exact situation, it would be incredibly unreasonable for this law to be applied to individuals who are statutorily authorized to tow illegally parked vehicles without their owner's consent. Finally, Section 46.2-1231 of the Virginia Code states that the owner of any parking lot may have any vehicle occupying the lot without the permission of the owner removed by towing. Once again, there is no readily available case law interpreting this statute, but based on the language of the statute, its application seems to be limited to parking lots and not open tracts of land like the lot where Mr. Raposo was parked.
The grounds that I have for this criminal matter are as follows.
It's not a criminal matter.
You are not to decide that, sir. You are not the judge.
That's
You are here to take a criminal report and nothing more. It needs to be handled accordingly. Well, I have to teach you guys because you guys...
You don't have to teach
I
me
do.
anything.
You guys do not study law. And it's the equivalent to a kitchen hiring a head chef who's never peeled an orange or held a knife or entered a kitchen in their whole
This ain't
life.
got nothing to do with a kitchen.
It absolutely does.
sir.
No, sir.
The county don't have
It
any
left the
property.
jurisdiction. Yes, it
Yeah.
does. And I'm going to teach you about
You
this,
ain't
sir.
gonna teach me nothing.
I'm not?
No,
Okay,
you're
are
not.
you too old to learn new tricks?
Look, well, we're trying to...
Okay. I still am requesting a supervisor.
And one's
on
not
scene.
coming.
Did you take the bar, sir? Did you take the bar?
No.
Did you take the ball?
I didn't have to take the bar.
We didn't either.
Where's your video?
Why don't you ask Franklin?
What did he say?
I'll go with it.
Oh, he said put him in handcuffs.
If you record,
Put your hands behind your back.
Why am I being arrested?
You're being under arrest right now, okay?
What? I'm sorry. Why are you detaining me?
While most of the officers were talking to Mr. Raposo, a few of the officers went inside the tow yard office and spoke with the individuals who work there. Prior to the officers arriving on the scene, Mr. Raposo had delivered some sort of handwritten document to the tow yard owner and informed him that he was, quote, under arrest before storming out of the building and presumably calling the Halifax County Sheriff's Office. For this reason, Mr. Raposo was placed under arrest for impersonating a police officer. Section 18.2-174 states that, quote, any person who falsely assumes or exercises the functions, powers, duties, and privileges incident to the office of sheriff, police officer, marshal, or other peace officer, or any local, city, county, state, or federal law enforcement officer, or who falsely assumes or pretends to be any such officer, is guilty of a Class 1 misdemeanor. Whether Mr. Raposo's actions actually constituted impersonation at least partially depends on the contents of the handwritten document he handed to Mr. Ellington. If he claimed to be a deputy sheriff on that document, as one of the officers later contends, Mr. Raposo's actions could be considered impersonating a police officer. However, based on Mr. Raposo's statements, it appears that he believed he was enacting a citizen's arrest, which is a common law doctrine that allows private citizens to arrest other citizens in certain situations. In the 1980 case of Tharp versus Commonwealth, the Supreme Court of Virginia confirmed that a private citizen has the right to make an arrest when a felony has actually been committed and the citizen has reasonable grounds for believing the person arrested had committed the crime. While it does not appear that a felony had been committed, Mr. Raposo was acting under the belief that one had been, which complicates the analysis of whether he was impersonating a police officer. Section 18.2-213 of the Virginia Code makes it a Class 4 misdemeanor to, quote, knowingly deliver any paper or writing simulating or intended to simulate any warrant, process, writ, notice of execution lien, or notice of motion for judgment for the purpose of collecting money. Without knowing the exact contents of the document, it's difficult to say whether it was intended to simulate a warrant or other legal process, but it's fairly clear from the situation that Mr. Raposo was not acting for the purpose of collecting money.
No, I did not tell him I was placing him under arrest. I did not impersonate an officer. I did not offer any information.
Sir, is that
and this
dog
right
your-
here is witness intimidation.
Is that your dog?
And this is suppressing my rights. Yes, sir, that is my dog.
In a comment on another YouTube video on his channel, Mr. Raposo stated that after he was arrested, the officers took him to jail and charged him with assuming the duties of law enforcement. However, in the comments for another video on the channel, Mr. Raposo stated that the charges were dropped, and also implied that he intended to file a 1983 lawsuit. I was unable to locate any court record that confirmed whether Mr. Raposo was charged with a criminal offense or had filed a lawsuit. Overall, the Halifax County Sheriff's deputies get an A-, because although the officers could have been more professional and contacted a supervisor when Mr. Raposo requested one, they remained within the bounds of their authority throughout the interaction and made what appeared to be a lawful arrest on Mr. Raposo without having to resort to violence. Some of the Halifax deputies' conduct could be seen as ethically and professionally questionable, but nothing the deputies did could be legitimately considered misconduct without more evidence to suggest otherwise. There is no doubt that the deputies should have been more cordial with Mr. Raposo when they initially made contact with him, but Mr. Raposo's condescending demeanor certainly did not help to facilitate a positive interaction. Judging by the videos uploaded to Mr. Raposo's YouTube channel, this is likely not the first time the Halifax County Sheriff's Office had interacted with Mr. Raposo regarding his RV being stolen, and that could be why the deputies refused to contact a sergeant. All that said, the presence of a superior may have had a dramatic effect on the overall hostility of the encounter, and while it could have been beneficial for a supervisor to be on scene, it likely would not have changed the outcome for Mr. Raposo. Mr. Raposo gets an F for serving handwritten papers to Mr. Ellington that bore no legal significance, failing to properly conduct a citizen's arrest, and for neglecting to file his original complaint through the proper channels. If Mr. Raposo's primary goal was to gain back possession over his RV, then it's difficult to understand why he was so reluctant to handle the matter through a civil court rather than a criminal court. Perhaps Mr. Raposo was considering the fact that if the case were criminal, then the state would fund the prosecution of the property owner and potentially return his RV free of charge. But if it were a civil case, then Mr. Raposo would be required to either hire an attorney or represent himself. And if he lost the civil case, then he could potentially be responsible for the property owner's legal fees. It should be noted that despite his claims, Mr. Raposo is not an attorney, and claiming to be an attorney without the proper certification certainly does not add credibility to his claims. It could also be possible that Mr. Raposo felt criminally wronged when his RV was taken, and he wanted a criminal prosecution to ensure that justice was served. Whatever the case may be, it's understandable for Mr. Raposo to be upset, given that most, if not all, of his worldly possessions were taken from him, and he may very well have a legitimate case if he can prove that his RV was parked at the property for less than 24 hours, as he claims. Mr. Raposo's obsession with what he perceived to be a personal injustice caused him to lose sight of his mission to retrieve his RV, and his inability to control his emotions ultimately led to his arrest. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out the ATA Patreon page for more police interaction content.